Hey everybody, it's John Kraska with EveryLibrary and the EveryLibrary Institute's Constitution Day 2025. We are continuing a big conversation about the law. It's kind of fascinating. All the problems that we have right now around what's happening in Washington, D.C. about libraries, whether it's the Institute of Museum and Library Services, where the executive order that was put out by President Trump back in March went a little too far. It's in the courts right now in Rhode Island and in that ALA-AFSCME case to try and pull back to what the law actually says. The issues around the Library of Congress are about the differences between an Article I constitutional institution, the of Congress part of Library of Congress, and overreach by the Article II entity, which is the president. All of it comes back to, with the censorship issues and the issues around discrimination, of course, the First Amendment, Constitution Day, and big conversations around how libraries fit into all this. I don't think we can have this conversation in the United States of America right now without bringing in our colleague Dan Novack from Penguin Random House and the team from Penguin Random House itself. The work that PRH has done on defending the First Amendment and extending right to read, extending the frameworks around what creators can do, has to be the biggest story of 2023, 24, definitely 2025, Dan. And I'm not blowing smoke at you. Thank you for being here today.
Thank you for having me.
Absolutely. So, folks, the official bio, Dan Novack, Vice President and Associate General Counsel of Penguin Random House, and a founding member of PRH's Intellectual Freedom Task Force. Dan, most people think of publishers as creating and distributing books, not filing lawsuits. Why has Penguin Random House chosen to wade so directly into First Amendment fights?
Yeah, I sometimes joke that we need to sell more books to finance the lawsuits, and we need to file the lawsuits to sell more books. It's like a snake eating its own tail.
Mm-hmm.
In seriousness, we had a realization a couple years ago now, a little more, boy, time flies, that these, what were once kind of isolated pockets of censorship, things that you'd read about with some curiosity, were becoming endemic, and in places where previously you didn't think that they would reach. And as it escalated, we decided as a company to take a sustained look at it and make a sustained response, a response that's proportionate with the scope of the problem. What really had started off as I'd say small batch censorship changed, certainly still a part of the paradigm here, but then it's morphed into this kind of state level top-down censorship. And at that point, we were the only people that had the resources and scale to really tackle it. Didn't think that we could put out books by our authors with, in a full-throated way, saying we stand behind these books if we're not going to actually support their ability to earn a living and sell them.
Absolutely. The idea that it moved from being a local politicized action to actually helping folks get elected to statewide office, and then the supercharging of it that's happening to a certain extent right now in Washington, D.C. You mentioned the state actors. I mean, Florida, Texas, Iowa, Idaho. I mean, I got a list,
Utah, South Carolina, Tennessee. Yeah, it's a long list.
And let's unpack a couple of them. So we got Florida here. Recently and earlier today on Constitution Day, we talked with Stefana Farrell, who runs the Florida Freedom Read Project, about her approach to the HB 1069, like the teaching of the lawsuit. Tell us a little bit about what it's like to be, in that, at the bar, as it were, arguing about the state of Florida in HB 1069.
Yeah. So the path to challenging 1069 is an interesting one. I'd say, in May of 2023, Penguin Random House joined PEN America in a legal challenge against a district in Florida, Escambia, which is like Pensacola area, that had removed hundreds of books that were woke or DEI or LGBT, any type of buzzword there. And I think it was maybe within a month of our lawsuit that this new bill got signed by Governor DeSantis, 1069. And whereas before censorship was kind of a game of whack-a-mole, where there could be hundreds of Escambia-like districts across the country, or even Florida alone, sadly, there were districts that were doing the right thing. And what 1069 did is take away their discretion to keep the books that their community wanted. And so, it boils down to a definition of pornography, that's the word they use in the statute, that was all-encompassing. that grabs books like 1984, As I Lay Dying, the works of Toni Morrison, James Baldwin, off the shelves permanently. And so it felt like the response to Escambia was like it's a great start. It's an important case, but what do we do about those districts that are trying to do the right thing? And so we were able to get a coalition together with other major publishers, Macmillan, Simon & Schuster, Hachette, Source Books, and HarperCollins, as well as the Authors Guild, as well as individual authors. And we said, enough's enough. And so we were able to challenge that law. Just recently, last month, a federal court blocked the implementation of that law. And again, it really came down to seeing what people like Stefana Farrell was doing, locally, those grassroots people, and figuring out where does a multinational, general interest trade publisher fit in here? Mm-hmm. Well, we have resources that they don't. So when we bring a case, we can really bring one. We hired outstanding lawyers from leading law firms to represent us. But also, I think on another level, we have access to arguments that your local parent or does not, right? We are a business. Courts recognize the economics of publishing are present in our cases, and so to me it's an advantage to have us there.
Yeah, and there's got to be a significant difference between Escambia County. So a local school district, a local library, their policies should be the most local expression of the Constitution. They should be following the law. They should be implementing a no fear, no favor framework on access to the collection and collection development choices. But when it's a state actor like that, how's the argument different though? You go into court with Escambia County, you go into court on the Gibson case. Is the approach significantly different?
There's a lot of commonality on the defense side. The arguments that the state and the district have made are virtually identical. In fact, the state, Florida, submitted an amicus brief in the Escambia case. Their argument is there is no First Amendment. It's an illusion. When a student steps into their school, they are a passive recipient of whatever ideology the state decides upon, and there is no exception to that. That's certainly something that in the curriculum context, we've seen some troubling trends. Mind you, we're only talking in these cases about libraries. So what we've said here is library is, to the extent that is true, that the state gets to decide its message, so be it. But in the library, that's supposed to be a place for independent inquiry. And they say, no, not really. Actually, it's the state speaking through its selection of library books. This is the so-called government speech doctrine. Mm-hmm. But then on our side of the equation, it is a little bit different because what we are saying in our state level challenges is not inconsistent with the local challenges, but there's an added step, which we're saying exactly what you just put forward, which is, well, hold on a second. What about local control here? Because we're fighting for the districts that want these books, right? So we're fighting for the parents that want these books or the students that want them, right? So ultimately, a case like Escambia is small batch, and historically there has been deference to what local districts want to do. Not absolute, not enough to protect what Escambia is doing. That's what we filed the challenge here. Mm-hmm. But at the state level, there's really no argument whatsoever for the state to step in and override the reading choices of local districts. I mean, we're talking about a bunch of elected officials from Tallahassee deciding what people across the state are reading. There's no history of that we can draw upon. We have examples of this type of thing, local censorship that stretch back a century, but the notion that a state legislature would do it, it's unusual to say the least. Yeah.
Mm-hmm. Well, the state of play at the same time as Gibson was in the courts and Escambia County was being both adjudicated and in that court of public opinion, we had a situation like HB 900 in Texas, yes, where they were trying to label the books. It's an extraordinary moment in America to see that the state's going to impose a rating system on books. And people, I think, forget that the rating system for movies, the rating system for video games are voluntary on the part of the industry. I don't see how you do it as a voluntary scheme in publishing. I don't think you should or can. But that being said, the state imposing that rating system, I mean, the marketplace sometimes drives public perception.
Yeah. Yes. So thank you for pointing out that those rating systems are completely voluntary. And by the way, I don't think have any history of, demonstrable history of working very well. I remember the Barbie movie got like a PG-13, and I couldn't exactly tell why. And then, sex is treated different than violence.
Oh my gosh.
Systems have not been, they're not models that I would advocate replicating. In Texas, what we were able to do as an industry, our trade group, the Association of American Publishers, challenged HB 900. Yes, on the grounds that it's a vague prohibition, that it forces you to label things in a certain way. What is sexual content? What is sexually explicit? It was very hard to define. Vagueness is a problem whenever you're dealing with speech. People need to know very clear boundaries of what's okay and what's not, because the consequences are really great if you have self-censorship. But we were able to say, well, look, this bill forces us to actually label our own stuff. Like, no way, compelled speech. So even the Fifth Circuit Court of Appeals, which went the absolute wrong way on this Little versus Lano case, and finding that there's no right to receive information in a library, public library, not even a school one, we said, this is too rich for our blood. We're not going to make them label it. And, I heard arguments in support of it. They'd say, well, the food people will label their stuff, ingredients. I'm like, okay, well, look, here, this is, flippant, but if there's any trans fats in a Penguin Random House title, I'll commit to labeling that.
There you go. There you go.
Once people start eating our books, I will commit to that. But
and you guys have a heck of a cookbook line. It's just
And we test those recipes to make sure that you don't get hurt by them. So it's we will vouch for the the safety. We sometimes put a disclaimer to be careful around eating mushrooms and things like that. But yeah, I mean we have a robust customer service line. I've never heard someone write in and say, I was hurt by this book. I mean, it doesn't happen. To the contrary, we have a lot of people that reach out to our authors, less so our customer service line, more to the authors or the editors saying, what an amazing book. This helped, change my life. Yeah.
Well, the role of the critic in your business is not what we're discussing here. It's the right to receive information, the right to.
Well, yes, but ultimately, what these standards are enforcing is a form of criticism. What they're saying is that the Supreme Court standard for if you're going to cast something aside because you don't like the sexual content, there's a standard. It's the obscenity standard. It's outlined in a case called Miller versus California, 1973. It's been around for quite a long time. And the Miller test says you have to look at the book as a whole and evaluate the whether it has literary, artistic, political, or scientific value. And what the proponents of book bans are saying is, well, they don't have value.
Right.
So you're just playing critic. Okay, I get it. Maybe Ulysses doesn't have value to you, but it does to me. So that's exactly the type of exercise they're not supposed to be engaged in, because that's policing ideas. So, ultimately, they kind of tell on themselves, because oftentimes the book banners will reveal that they haven't read the book. And of course, the laws like 1069 in Florida, similar laws that we've challenged in Iowa and Idaho, they go on the basis of a single line. They explicitly say if there is one reference, throw the baby out with the bathwater.
Well, it's interesting. So the taken as a whole, is a component of that as well. But so is that contemporary community standard. And in a situation like in Iowa, let's talk about these for a minute. Iowa and Idaho, and it's hard sometimes for me to keep those two words in my mouth properly, but Iowa with Senate File 496, Idaho with HB 710, the contemporary part of contemporary community standards, the majority might be pretty uncomfortable with the LGBTQ themes. And it's part of a broader fight. I mean, no offense, those laws were both part of a larger anti-person initiative in those states.
It's no accident. 496 in Iowa was part of a larger bill that regulated use of pronouns, gender-neutral bathrooms. I mean, it's toxic stuff. And ultimately, I do think these laws are attacks on certain identities. I mean, primarily LGBT, although you see a lot of attacks on critical race theory, which is, and attacks on immigrants and their stories. So, yeah, there's definitely a larger cultural context here that's at play. When we think about the community that we're supposed to weigh, there's a lot of good case law over the years that says you're not supposed to use a microscope for that community. Right. Go broader. And even if you were to restrict yourself to the social mores of people in Des Moines, Iowa, it still doesn't get you out of the analysis of whether the book has value. There are a lot of books that shock the conscience that have value. I mean, Mein Kampf, like, this is an easy case here. Like, it's a book that shocks the conscience. It should not be there as a how-to manual, right? But it's a cautionary tale, and that book absolutely belongs in libraries. And so we don't have to say that we like the book for it to be there. And there's books that poke, prod, challenge. I mean, Ulysses is a great example. I mean, I've never read Ulysses. The right to read and the right not to read are the same to me, and I proudly exercise my right not to read, Ulysses. I actually had the pleasure of watching a staged performance of certain of the trial of Ulysses, actually, and where they showed the scenes, and it's like, it's actually pretty tame by today's standards, but it's out there, and but the whole point is, like, okay, I could be scandalized for a moment, but then there's 600 other pages of stuff, you can't, you have to account for. So, there's always going to be upsetting stuff in great books. That's the whole point. It's supposed to provoke a response. Yeah.
Well, I mean, the Iowa 496, the Idaho 710, we've been talking about the First Amendment here, but how much does the court care about the 14th Amendment issues as well?
It is
the equal protection side of it, more that civil rights side of it.
It is an argument, the idea that when you have a book banned, like in Escambia, that is explicitly premised on certain identities, and it's LGBT, but it's also African American or just broadly immigrant experience, or Latino identities. It's like it's palpable. You can, like, that is motivating what's going on there.
Right.
We did assert a 14th Amendment claim saying, well, this policy seems to be treating people differently based on their, ethnic or race or national origin, or gender. So ultimately, in that case, the court found that, well, a white person can write a book about a black person, a gay person can read a book by a straight person. So Judge Wetherell in that case was unwilling to find 14th Amendment, at least at the outset, because he found that it's not really discriminating against the authors. I don't agree with that analysis, but I think that was a kind of a good indicator of the level of skepticism that we will face with 14th Amendment. So we did not put forward a 14th Amendment claim in our statewide challenge to 1069. We did it on pure First Amendment grounds. We followed that. We also did that elsewhere. And to be clear, that discrimination can come into the First Amendment in a different way, because we're saying it's viewpoint discrimination. We're saying, for example, in Idaho, where it says you can't have sexual acts or homosexual acts, that's obvious discrimination, but we're putting it through a First Amendment lens of viewpoint discrimination. And, that case is still in process. We don't have an answer on that one yet, but so it colors the case, but it is not something that, by and large, we are advancing as a formal, argument.
So, I'm not challenging the doctrinal, approach here in any of the cases. It's that broad conversation. If it's about if it's about free expression, if it's about identity, what are the tools that are available? We have a situation right now, as you know, where the Alabama Public Library Services Board, the State Advisory Board, is promulgating a set of draft rules. They're up for comment right now through our friends at Read Freely Alabama, that would prohibit the positive depiction of anyone who's not straight, cisgendered, heteronormative. And that is an extraordinary thing. And how do you find a human rights conversation in there, a civil rights conversation in there, alongside that First Amendment, space? And I think there's room to go.
Absolutely. We're taking a long view of this, and so we're trying to build precedent upon precedent, and it's informed by a view of how far we can go at the moment. And we have difficult conversations with allies to say, like, we're making this strategic choice because we need to, get this foothold first before we go for the next one. It requires them to trust us that we will actually keep going, and instead of packing up when we're, declare victory early. What I've seen so far is, for example, in in Iowa, we didn't challenge the other LGBT. We didn't have standing to challenge that, but there's a companion case
There is.
at ACLU that challenged it. And initially the court said, yeah, this is crazy. This has to all go out. But then the appellate court said, well, we're just going to read this a different way. And when it says you can't be positive about this, they mean you can't instruct people to, like, they're adding meaning there. They're filling in blanks, or they're kind of taking their glasses off, I think, and reading it a little fuzzy sometimes. But there is a phenomenon of judges that will stretch to fix the statute rather than toss it out. In Idaho, even though we have not yet gotten it really in our case, there's another case involving private schools and libraries where that homosexual acts language was said, well, it's just inclusive of sex. Why is it it's written in addition to, it's a list, but the district court said, let's just read it as one and the same. So, no harm done. And it's like, well, there is, so we're saying, no, there is harm when you do that. It's effectuating prejudice. It's on the books. So it's been a challenge, but ultimately the path to justice is going to go through a lot of different types of judges. We draw whoever we draw. Sitting here, I was asked, sitting in the same spot 2.5 years ago, can we get this through a Trump judiciary? And I said yes. Yeah. But we have to use arguments that are available to us where they see common ground. And so we oftentimes are, one of the advantages of paying a Random House is that we have the backlist. So we can find that book that will unlock a sense of confusion, outrage, I hope, in any judge that, wait, why, like, if we want to save a book like Genderqueer, which is a challenging book for some students, that's not hardly universally in all libraries, the school libraries, far from it. How do we save that book, access to that book? Well, if the same law bans 1984, like, we can talk about 1984 and we might connect with someone that might have a harder time finding their way towards compassion for everyone else's stories. We've made a lot of, like I said, that has been a strategic choice for us, is to focus on classics oftentimes, because that's where we can find common ground, and we certainly have enough of them. I mean, I remember having a conversation with a journalist that was initially skeptical. Why can't people decide for their own? It's like, they're abandoning The Outsiders. And he said, The Outsiders?
Are you kidding me? Right? Yeah. Oh, stay gold, pony boy. Stay gold.
I don't know. There's something in there someone doesn't like. And he says, oh, that's wild. And then, like, the conversation just, like, the terrain under our ground shifted. And so we're always searching for, like, that touch point for judges, right? But also legislators. But different conversations, but sure. But, like, we have to get it through the courts. And I want whatever justices Thomas, Alito, Gorsuch, Coney Barrett, Kagan, Jackson, Sotomayor, it's like, whatever their favorite books are, I hope that they
I hope that we can find that conversation. Absolutely. So beyond the courts, though, one of the things that we've been involved in Common Cause has been things like the Libraries for All Act in Delaware and in Vermont, where we brought in those Title III civil rights protections for access to the library. And the Colorado rewrites that were done this year in order to move the Colorado School Library Right to Read bill along, that not only was about the First Amendment and PICO and the Miller test, but it was also about the protected minority classes seeing themselves in the collections. And then you folks have been, and Dan, you personally and professionally, the Rhode Island legislation around Freedom to Read Act and the innovation there. And I'm not saying it's a novel legal theory, but it certainly is. I mean, you're definitely moving things forward in terms
very
of
standard, just regular stuff.
Absolutely. How do we protect not only how does the Rhode Island bill, the Freedom to Read Act there, it codifies First Amendment. It brings forward the people whose books are on the shelves and the protection against majority discomfort, but also you've moved some things forward around support for creators.
Yes.
Yes.
Well, I'm going to give some return some of these flowers to you, John. I looked at what you were able to do in places and move people to write legislation and get it through, and I thought, okay, we could try this. and now we work together on them, which is great.
Mm-hmm.
And what I think unlocked a lot of potential in Rhode Island, which right now has the strongest bill, mm-hmm. is that we really brought everyone to the party, including EveryLibrary. But like, we had faith leaders, we had student groups, we had, mm-hmm. Of course, the Rhode Island Library Association, mm-hmm. and really critically, the Authors Against Book Bans, which is a newer group created, thousands of members. They're all just working authors that have no tolerance for censorship, and they have a Rhode Island chapter, and Padma and Jeanette, my friends in Rhode Island now, were like, loudly but politely insistent with their legislators that they needed to be protected. And so what that meant is that we had a really strong coalition, but that we were able to bring in every constituency. So the bill reflects that, I think. The bill says that if you are an author that's had their book unlawfully removed, you have the ability to get the book back on the shelf. That's something that you could do in federal court, but we're like, we're in federal court. I'm involved in 4 cases directly and supporting many more with amicus. Mm-hmm. There's no fast lane in federal court. There's a form of roulette that you're playing with judges. Like, people mm-hmm. should be able to the state should step in. Yeah. So we got our creator provision in there. The most important thing that we got in there is that some bills say, well, don't ban the book, but then what? Is the Attorney General going to bring a case? Is the Department of Ed going to, like that? I don't want to rely upon a bureaucrat or a politician to vindicate my rights. So what Rhode Island did is say, if you've had your rights violated as a student or a parent or an author, you can go to court in Rhode Island and get the book back. Mm-hmm. I think that that's a great model. It's not, I'm joking that it's new in the sense that it's the first time a state has recognized it as a personal right, mm-hmm. that the state puts actual force behind. But we've seen that in other ways. So the analogy we offered to kind of explain it to legislators is, well, after the Dobbs decision of the Supreme Court, when women can no longer rely upon the Constitution for their reproductive care, states stepped in. They codified Roe. That was the catchphrase, codify Roe. So we are codifying PICO, no ideological book bans, and codifying Miller, the appropriate obscenity standard. Mm-hmm. And so it's not new, but it's an opportunity for states to step in to that void and not have people be uncovered, right? So it was such a great coalition. Not everyone agrees on every single thing, but we always worked it out, and we spoke with one voice. The Authors Against Books Bans did incredible mobilization. The Rhode Island Library Association did incredible mobilization, mm-hmm. postcards, events, everything. I mean, we really love bombed a lot of legislators. Mm-hmm. And it's not hard to explain to them. I mean, even I would say in a state like Rhode Island, where it was an easy target for a pickup for us because it's the Democrats have control of all 3 chambers. That doesn't mean that that's the only places where we can get that done. We've had very nice conversations with Republican legislators. Mm-hmm. They're curious. I think that they're still like, they think the plate's hot sometimes, but we're telling them it's okay. Mm-hmm. But that's, once we had that passed, this, like, we go to another state like Massachusetts and say, well, Rhode Island just did this, right? So it's not new anymore. Mm-hmm. And there's
absolutely no, that kind of dialogue opportunity is pretty significant. And then we have our neighbors in New Hampshire, who right now the biggest thing that we could have happened was just a good rule of law veto. Our neighbors in North Dakota, good rule of law veto. What does the Constitution actually say of bad ideas?
Veto it, and the thing is, what we say to them is, we will come back to the table with you.
That's right.
There is a lot of persistent confusion about what the word parental rights means. Mm-hmm. It's a word that's been used as a bludgeon to take away other people's children's books, right? So mm-hmm. that's not parental rights to me. So some legislators think that books are being foisted upon kids. Not really true in any sense, but what if we give them a bill that says, by the way, as a parent, you can choose what your kid reads. Right. So they feel seen, and we will work with them. I have no fear over a parent having access to, like, knowing which books we sell. Like, we stand behind them. So I'm not worried that we have to be secretive about which books Ping and Random House is selling in the library. Like, we can have transparency.
Absolutely.
And some parents have more tolerance for certain ideas at a certain age or whatever. it's not how I parent my kids, but I can't reach across. I can't, as much as I want my neighbors' kids to benefit from the great books that I'm making available, my town is making available to my kids. Like, I don't force anyone to read anything. So getting a kid to read at all voluntarily is like a big victory. So,
oh my gosh, like that's a whole other conversation. And
one of my, you can tell I have a lot of jokes because I have to keep it light. Otherwise, it's just so dark. Is that I tell people if there's truly, many of the books that are on these lists of banned titles are books that have been around since I was a kid.
Mm-hmm.
And if I had known there was pornography in the library as a kid, boy, you'd have to pry me out of that building.
You're going to Walden Books otherwise.
We sure we're talking about the same place here? I don't remember that being where the porn was.
Dan, there's so many things that we didn't touch on today, but we're coming up at the end. I mean, I'd love to get your thoughts on what it means that every judge who's ruled recently on a particular book has said it doesn't meet the Miller test. I'd love to get your thoughts, on situations like Huntington Beach, the ACLU lawsuit there that just used the state law for the first time over there. But we're out. We're over half an hour. We gotta hit the road.
We're winning. We're gaining momentum.
That's what I was just going to ask. Is how you feeling?
It's just a matter of time. We have to just stay the course.
Mm-hmm.
There's a larger cultural project that we're all involved in here. Not lost. I mean, that we have litigation, legislation, and then that cultural work. That cultural work is what will actually cement and solidify all these gains. But the law is what will create the opening for that, in my view. And we're like that fullback blasting through the line here so that the people that are in these states can build coalitions and sustain that right to read.
That's fantastic. I'm glad to be in coalition with you and the team at Penguin Random House. I can tell you that the when the history of this era is written, your name is going to be more than a footnote, Dan, personally, and Skip Dye and the other members of your team.
And that history assumes that there will be books in the future. So things must have really worked out well.
Well, I mean, if you put enough out on the internet with the AI, they'll pick it up. Don't worry.
They'll pick it up. Thank you.
Pick it up.
Appreciate it.
Dan, here at EveryLibrary Live, we always say thank you to each other, and I appreciate you very much again. And we also wave at the camera while I hit end recording and take you out to the green room, and I'll check in with you there.
Goodbye.
Thank you.